Members, what we're going to take up next is House Bill 470. It was a late addition last night at a request of the author, who's also a committee member, even though he's not here right now. I believe he's possibly qualifying for another race. Sheriff, Representative Lyons has given you permission and informed me that he'd like you to present the bill if he's not here. So we'd like to take up House Bill 470 at this time, if you're okay with that.
Chairman, do you have a copy of the bill that I can get?
I will get you one
right,
in 2 seconds. Yes, sir.
Perfect.
Give Valerie another copy now. And filling out a green card in support would like to speak Sheriff Joe Lopinto, Jefferson Parish Sheriff's Office.
Thank you, Mr. Chairman and members. The purpose of HBL 470 is, with my talking with Representative Lyons and many others over the years, right? Many of y'all know is my position as Sheriff of Jefferson Parish. I have the largest sheriff's office in the state of Louisiana. And one of the bigger topics over the past few years has been body cameras. It's easy for smaller departments that may be under city government to be able to defend themselves, be able to have different types of things. But when you're dealing with the sheriff's office, it'll look at different perspectives, right? We handle almost 400,000 calls for service a year in Jefferson Parish. I am not a rural sheriff handling small calls for service. I've got a very large population of 430,000 people, which makes it a little bit different from me. It's 430,000 people, and less than a quarter of it is incorporated, meaning that I am the jailer for the entire population of Jefferson Parish. I'm the sheriff's office, which is the deputies for 3/4 of the parish, and as many of y'all know, I'm also the tax collector of that parish, right? And so we look at the different things of how do we implement it. It's not a situation of me just putting a camera on my chest and walk around and making that happen. We make probably 20,000 arrests in Jefferson Parish, but handling almost 400,000 calls for service. This is not about the arrest. This is not about the police officer involved shooting. This is about all the other data that comes in from the sheriff's office on a regular basis. So when we were looking at it, we know that just the hardware itself is going to be probably $2 million a year in Jefferson Parish just for that. Not including the ability to be able to redact it, the personnel that I've got to put on to handle that extra data, to be able to, have all the requests. In Jefferson Parish, we have about 1,000 public records requests a month that come through. So it's a big deal. And so what I did is I didn't take this, lightly. I had my staff go and look at every state that's out there. Every single state, let me know what the body camera legislation is in different states. And they're all different. Many states, the state of Georgia, it's just not a public record. Body camera footage is not a public record at all. Other states, if the body camera footage is within the privacy of someone's own home, it's not a public record. Other states, if it's not attached to a criminal case, it's not a public record. So we are not like that in Louisiana. In Louisiana, we don't sit there and say that this is a public record, this isn't a public record. We make it all a public record. And what we have done is to try to address some of the privacy concerns. Look, I always know if my police officer shoots someone, that's going to be attached to a criminal case. That's going to be available, and that's going to be part of that issue. And that's what people believe and think about when they're dealing with body camera footage. But it's all the other footage that we have to deal with, whether it's the domestic violence issues, whether it's the suicides. The different things that are out there that police officers see on a regular basis that the public doesn't get to see. Sometimes they probably shouldn't see. Right? We don't want your family member that, has been through a tragic death, and then I have a loved one, that's on the other side of the family that decides, I want to copy that footage. I want to make sure. And people, let's face it, some of them don't have couth these days. This is not really a press issue. Truthfully, I didn't expect the press to be against it, to be honest with you, because there's certain things that I'm trying to accomplish. I didn't come here saying that this footage is not going to be a public record. I didn't try to change it to say footage inside your privacy of your home was not a public record. But when you make the custodian the judger of couth, it becomes a problem. So if our deputies are, called out to an alarm in that house, doors open, we walk through the house. There's no burglary, the wind blew it open, whatever the case may be, and we mark it up and it's gone. Now, come to find out, the ex-spouse of that house is in a child support or spousal support case and says, you know what, I want to know what the inside of the house is. I want to see what the TVs they bought, and I want to do that type of stuff. And they come to the sheriff's office to ask for a copy of the videotape. Should I give a stranger a copy of the videotape of the inside of somebody's house because we went on an alarm? Truthfully, I don't have a dog in that hunt. I don't care what the answer is. But I'm going to protect that person's privacy rights, and I'm going to say no. And I'm going to let the judge make a decision. Under the current law in Louisiana, if I don't turn that over, no matter what the circumstances, if the judge rules against me and says, no, I think it's reasonable, you can redact this or whatever the case may be and turn it over, I've got to pay that other party's attorney's fees. I'm trying to look at ways to lower my liability on the sheriff's office to make sure that I can afford the benefits that are there for cameras at the end of the day. So it's not something that I'm trying to sit there and stretch or do anything with. If I make a reasonable regional objection to an exception that's in place, that's currently in place, I shouldn't be forced to pay the attorney's fees the other side, as long as that was reasonable. Now, if I tell the press, tough luck, you're not getting it, and it is not reasonable when the judge orders that, then guess what? I should have to pay for that. Absolutely. No doubt about it, right? But that's the problem when you deal with discretion from the custodian of what is reasonable, what is somebody's privacy rights, and what is not. And I can make a whole bunch of examples, right? I mean, I can give you the cases of swatting that is, very popular now. We've got the YouTubers that will literally call 911, and we had one 2 weeks ago where they called and claimed that there was a bomb in the New Orleans airport. And they called 3 times, and, we pretty much knew it was a joke, but we, of course, had to take actions from it. And the entire time, the person is, trying to say there's a bomb, trying to disguise the voice, do everything else. And I come at the end of it, and he's dying laughing because, of course, he audio recorded this, and he's going to put it on TikTok or whatever the case may be, right? And there's people out there that will utilize those events, that will call us to scenes that are improper. And then who knows where that request comes in. And I just don't have a lot of trust in that. I do have trust for the press. I do believe that most of our press, whether we like it or not, they still have some journalistic standards that they will deal with. But that's not the case for every TikToker. And that's just the bottom line, right? And so that is kind of what we've put together to try to make this, as non-controversial as possible, to allow us to be able to, take a little bit further steps forward to try to implement those cameras in the future. And that was always been my conversation with Representative Lyons of what can we do? What can we make that happen? We've talked about those examples. We've agreed on those examples. And we came forward with this. Again, it's not changing what is and what is not a public record dealing with body cameras. It is when you put us in the position to make a decision of what is somebody's private rights and what is not. I shouldn't be responsible for making a reasonable decision and then being overruled by the judge. And that's what we did and came forward with.
Sheriff, so I'm looking at the language that you're kind of double covering it, though. So, I mean, if we change the shall to a may, which gives the judge discretion on whether or not to award attorney's fees, but you're also adding that extra language if the judge determines that there was no reasonable basis, I feel like you could keep the shall with that added language, and then that would accomplish your goal. But I also think you could strike the added language and do the may, which gives the judge more discretion. I don't know if both are necessary.
I don't necessarily. I thought the shall to may is obviously, you change the shall to the may, then that's what they're deciding on anyway. The extra language, to be honest with you, I thought was a detriment to the sheriff's office, but it made it clearer what we were trying to accomplish, right? And that's the reason we put that language in there. So if the judge determines that there's no reasonable basis for my denial, then I should have to pay. Right. So the judge has to it's not a situation where the judge, can make that decision and just not give him attorney fees. If they make the decision that there was no reasonable basis for my denial, then I should have to pay the attorney's fees, and that's why we put the language in there. So changing the shall to may and taking out the other line actually helps the sheriff's office, but I'm not sure that's really what the intention of the bill to do is. I'm up to all kind of ideas. I'm not a product ownership type author type deal. Anybody can offer amendments, but that is what we're trying to accomplish and deal with.
Okay, and then also you're striking subsection C in the earlier part, which says that all costs of production associated with a court-ordered disclosure shall be set by the court. What's the reasoning for that?
And because we've kind of seen it all different ways, right? Each, I really, again, that's not something that I'm tied to, but everybody's body camera process can be different, and cost can be different from that standpoint, right? So we may make our costs based off of certain software that we have that is not necessarily the same for another judge someplace else or another sheriff's office someplace else, right? So it allows the sheriff's office to make that determination of what that reasonable cost should be. Truthfully, I have faith in my judges that they're going to make a reasonable decision, off of it, what it should be. But that being said, that was the purpose of it.
And I guess, isn't that going to have, if we're talking about litigation here, isn't that's going to be something that's done through discovery? I would see, hey, look, I prevailed at court. I need are we thinking about the cost in the same way of you prevail and these are your costs associated with
no. I was thinking about that. No, literally, I was thinking about the cost of the footage itself. So let's say I charge $75 for a body cam footage to be transferred. It'd be $75, not the cost.
Oh, so when someone's seeking that information, you're saying
not
actually
the cost of litigation. Correct.
Okay, all right. I was thinking of it
and
wrong.
then also the other portion. In the past we specifically dealt with just body cameras. We have all kind of cameras. I have body cameras. I have vehicle cameras. I have drone footage now. We literally had a case the other day. We utilize our drones more than anything, and our robots more than anything. That is the same type of stuff. It was a SWAT role, a person that was attempting suicide. He ends up going inside of his bed. Now, he had taken a lot of medication and actually passed out sleeping. We flew the drone inside his house and have him laying on his bed with the gun in his hand, finger on the trigger, sleeping. We ended up having to send deputies in with shields, and we're literally able to grab the gun out of his hand completely on video camera. And again, on the current law, that's not body cam video. It's a drone footage, right? Technology changes, and so when we're dealing with video and audio tape, that's the difference. We can make laws 3 years ago that aren't the same as what they are today. Now, most other sheriff's offices in this state don't have the ability that I have, fly drones through a house and do all that type of stuff. You need, certain pilot license and all that type of stuff to make that work. But, I'm trying to keep that up with the time and making those slight changes.
Thank you. We do have a question, and I forgot. I introduced you as the sheriff, but you are a former legislator. We welcome you back. I should have started it that way, but we do welcome you back.
I appreciate it. It's not often I get to sit at these tables. I wish for sine die every day.
For a question, Representative Ivey.
Thank you, Mr. Chairman. I'm trying to understand what's really being affected in this. Right now, if you believe that you should withhold something because it's personal nature and not for public consumption, you do that now, and then someone sues, you go to court, and the judge makes the determination. Correct. And so if in the judge's opinion it wasn't reasonable, he says you have to produce it, and he can award attorney's fees and things like that. What changes?
So if the judge rules that it is not reasonable, or it doesn't have to be not reasonable. I'll give you one that I just made the decision on recently. Most of y'all are familiar with the gun store shooting that I had not too long ago on Airline, right? We have video camera footage that wasn't body camera footage, but we have video camera footage that literally shows this victim being shot and falling to the ground. Now, I chose not to air that to the media. Wasn't going to do it, and I'm not going to let somebody see their mother get shot on videotape just for the sake of it, right? It's not going to happen.
Sure.
And so that doesn't necessarily mean that there aren't stations around or agendas around this nation that would sit there and go look for that and say, you know what, we want it. We want to make this into a gun control issue or gun control issue and take that and say, this is what happens when you don't have guns and make that happen. So I can make the determination that I think this could violate somebody's privacy rights, and I'm going to make a judge sign on the dotted line and tell me whether or not that's released or not released. Because guess what? That's not an open criminal case. The guy was shot and killed on the scene. So I don't have an open criminal investigation exception. I don't have any of that to happen, right? And so if I make the decision that that's somebody's privacy rights and the judge comes back and says, Sheriff, I still think they should be able to have it, and I'm going to give them a copy of it, I made a reasonable decision that was somebody's privacy rights. The judge overruled me. I'm okay with being overruled.
Make the judge do it.
But when I'm overruled by the judge, I shouldn't be responsible for the attorney's fees from the other side. I should be responsible for my own attorney's fees. I shouldn't be responsible for the attorney's fees on the other side for making that argument and winning. I don't have a problem that they won. Sometimes, as I said earlier, I don't have a dog in that hunt of what the outcome is. But I'm gonna make a judge make the decision of whether, somebody's, spouses getting in an argument is something that's out there. If they're in the privacy of their own home and having an argument, it's one thing. If they're at a ballpark and having an argument, they have a less duty of personal responsibility from themselves, but they don't have a privacy request when they were out at the middle of a park, right? And so I've got to weigh all of those different exceptions, that have come across on every single call for service that we handle, and then try to make a determination of whether this is reasonable or not reasonable.
Sure.
Right?
Well,
and that's the difference.
Well, I get and I appreciate that, and I know it's so nuanced, and in all of the situations, no, we can't write law that would perfectly define every scenario and when it is, a public interest and when it's not. So I respect the challenge, but is a judge required right now to make the government agency and law enforcement actually pay for the attorney's fees? So
in today's world, what happens is if someone comes in the sheriff's office and says, I'd like the body cam footage or whatever, this is not limited to body cam footage, but I'd like this document or this body cam footage on this item number. Okay. So I can do two things. I look at the video and I say, okay, no, it's not a open investigation. There's no privacy issues with it. I can turn it over. Pay me the fee, and I turn it over. If I look at it and I believe it does have the ability to violate somebody's privacy rights, whether it's in their hospital bed or whatever the case may be, right? I then deny it. I say it's denied based off of it could violate somebody's reasonable privacy rights, right? Right. They at that time follow an action against me, mandamus action against me for me to produce it. Right. We go to the court. Court, this is what it is. Let them view it in camera inspection. This is what we have. This is why we made the exception. If the judge says, I'm going to give it to them, they shall award attorney's fees to the other side.
Right. But the standard that the court is using now to determine whether or not y'all are required by law to produce, the footage or not is more narrow in scope. You know what I'm saying? It's more broad. It's broader.
Again,
because what you're doing, like the word we're injecting the word potentially violate. I have concern with potentially. Potentially, I don't know the jurisprudence on the word potentially.
There is none. I mean, let's face it. Every incident that we have is different, Representative Ivey, right?
But currently, without the word, you're standing for not, providing that video footage is that you believe it does violate an individual's privacy rights.
Well, I'm realistic to know that every one of us can have a different opinion. Let's face it. Joe Lapinto is not going to be the person that's going to be looking at the videotape. right? I mean, my head of custodian of records is going to get 1,000 records requests every single month, and they're going to go through it, and they're going to look at it, and they're going to make a determination of whether they think somebody has an action against this or not, right? I mean, and if it's you and the police officer, well, no, you can come get the videotape because obviously it doesn't violate your own privacy right. But if it's but if it's a third party coming to ask for that document, they're going to put a little pause on it. Okay, what is the purpose of this, right? And so my custodian has to make a judgment call at that point in time of whether this or will or will not hold up in court. And many times, as I said before, we don't really care what the outcome is, but we don't want to release something to somebody, a third party, it be used against somebody else, and now I'm being accused of violating somebody's rights and giving something away on one end, when the opposite end of it is y'all go fight that out. Go fight it out. Tell me who wins, and I'll give you the videotape. Right. But I don't necessarily need to be in the mix of it, and that's the difference.
Right. So for clarification, when we're talking about I'm trying to use the phrase, an individual's privacy, right? The privacy, does that include, does law enforcement operating in their official capacity, a part of, where they're on footage, whether it be a body cam or some other, thing, is there any expectation or right of privacy or any interpretation by law enforcement when requesting video that could fall under their right to privacy?
So one, that allows already in certain cases, depending on what it is, if they're acting in the course and scope of their duty, the answer is no, right?
If they're just jaw jacking with their buddy in the car, that's private, not related,
right? So there would be certain situations like that. The issue is what's on the camera. That I guess it depends on the use of what's being there, right? If my deputy has an interaction with someone. And the complaint comes in as whether it's a rudeness complaint of my deputy. No, that's certainly going to be able to be discoverable or turned over from that particular case.
But is it
right?
only by the complainant if they were a participant in that, or the general public?
I did not. There is statutes at other parts of the state that specifically say it's only discoverable to the person that is in the video, right?
And so that's defined.
We are not that restrictive.
Okay.
Look, if we had all those laws, I wouldn't need this one.
Yep.
You know what I mean? And that's what it comes down to, right? If we had all the laws of the other states that restricted it from that standpoint, I wouldn't need this one. We don't. And so if the person that's having the interaction with the policeman, they don't really have a right from a privacy because it's two people interacting, right? But if I have a third party that's requesting the video footage of the policeman and an individual inside of someone's house, that's where there's a little bit different story, right? You know what I mean? And I don't necessarily always know what the reasoning for the request is. And so from my situation, it is, do I have a responsibility to go to the person that is in the video with me to say, look, this person's requesting and it's going to show the inside of the house. It's going to show your kids. Do I give it to them? Do I not give it to them? Do you need to sign a waiver? Do I not? Those are the issues that come up on and have been litigated around this country. I mean, and it's not often. I mean, let me tell you, this doesn't happen every single day. So, but it puts us in a predicament that we got to try to figure it out.
Right. So my biggest concern is that by expanding the validation, or how law enforcement validates not providing it, right, refusing to provide the video to potential, that again, not necessarily with your department, and again, you only represent your own agency, but that it could basically be the point that every law enforcement or many law enforcement agencies use to require a lawsuit for everything.
Well, Representative, the problem with that theory is Jefferson Parish Sheriff's Office doesn't have body cameras now.
Well, I'm talking about video footage.
But we're trying to get to a portion where we can, right? And that's the difference. It's not a situation where, I'm looking to hide this information. I'm realistic to know when I have this information, I've got a lot of responsibility with it. And that's the difference, right?
And I understand and appreciate, but my point is that I think we're expanding the ability to refuse with no consequence to the agency on the refusal when it's, again, it's not a very high burden of proof to say, well, potentially, potential.
No, and I think the difference is here is it gives the judge the ability to see. I think it's a little bit different because I think it gives the judge the ability to agree with me from a standpoint of, yes, that was a private matter, but I'm going to give it to him anyway. But
I would be okay if we had
right?
stripped some of those language out and just made the fees
the alternative
permissive.
The alternative is the judge rules in my favor. The judge rules in my favor and says you don't get it. They don't get attorney's fees, plus they don't get the document.
Right.
This gives them the ability to still get the document, but not make me responsible for attorney's fees when I made a reasonable decision on behalf of it.
Right, but we could just authorize the judge to do that without expanding, adding the words potential.
So if you look at I think that I don't care about the potential word, right?
Okay.
I mean, the difference is video audio recordings that are determined by the custodian to violate an individual's reasonable expectation privacy.
Right.
My custodian's gonna, it's those
do their best.
It's those gray areas.
They're gonna
right?
do their best.
And
look,
so that's what's happening, right? I mean, I thought potentially was the proper word because on the ones that are clear cut, the green, we're giving it. On the ones that are clear cut, the red, we're not giving it.
But
It's the ones that are in the middle.
But you're not married to potentially.
I'm not.
Okay.
Look, I'm gonna offer up an amendment.
Okay. I got one last question. Just curious on the necessity. So we eliminate body worn camera video and just say video like in A. Is this just kind of a consolidating language?
Because I mean, like right
Any
now,
video with a body
I have video camera footage on my tasers.
I got
you know what I mean? We don't utilize.
The technology's evolving where video's on everything
Correct.
these days. Okay.
So it all depends on what you're talking about. I mean, whether it's a body worn camera, whether it's a camera that's sitting on my SWAT truck,
Gotcha.
doesn't really make a difference.
Perfect. Thank you.
Thank you, Representative Ivey. Members, I'm going to offer up. I had an amendment passed out to you, which is the intent is, Sheriff. What I want to do is I want to change the may back to a shall, but I want to keep your language in because I think that ultimately accomplishes your goal. It says that they get the attorney's fees if the judge determines there was no reasonable basis.
That's fine.
And so that I'm going to offer that up, but I'm going to also offer up an amendment in concept to as well to remove the potentially violate. If that gives maybe some members a little headache, we do that, and I think that accomplishes one of your main goals. So I'm going to offer up the may to the shall, and then remove the potentially on page 2, line 3. Is there any? And then what else? 7 and 15. So we're going to remove the potentiallys, and we're going back to shall. You have a question on that amendment? Go ahead, Representative Horton.
Concern is that the purpose of the bill is to allow any of our law enforcement, sheriffs, chiefs, whoever, to make the decision that it is a violation. And if a judge rules differently, the law enforcement officer should not have to bear the burden of the cost. So does your
that second language will still cover him. It says if the judge determines there was no reasonable basis.
Sure. I'm sorry.
No problem.
I agree, Representative. It's a play on words. I think it accomplishes it both ways, but I'm not.
Yeah,
I think if the judge makes a determination that I had no reasonable basis for the denial, I don't have a problem paying attorney's fees. I'm back to square one. But so I think that doesn't bother me. Yeah,
Ms. White.
Good morning, Mr. Chairman, committee members. Karen White, Executive Counsel for the Louisiana Municipal Association. To the proposed amendment, I appreciate what the chairman is attempting to do. I would have concerns under your proposal of changing the may back to shall, but leaving the reasonable language in there. If you were to also remove potentially, and here's why. The court's determination ultimately as to whether or not the Custodians Act was reasonable or not is based on the standard that's articulated in Title 44, right? So the standard currently is it has to violate. So the custodian is charged now under current law with determining definitively that disclosure, right, would violate, period. Not that it may violate, that it does violate. Putting them in the shoes essentially of the judicial branch to try to make that determination. So I fully appreciate what you're doing. I would suggest humbly that if your intention is to change the may back to shall, for the awarding of fees, leaving the standard of a reasonable determination, right? Did the custodian make a reasonable determination, that you kindly leave potentially in there, because that is, in reality, what the custodian is doing. They are weighing all of the potential litigation that's out there.
But a
and saying,
reasonableness test is going to bring in all kind of things. It is not referencing that specific language is not referencing that line and saying that's the judge's only determination. The judge is going to make a holistic determination on what he believed was reasonable. If he believes the sheriff's department was reasonable, I disagree.
So-
I see your point that it does expand it somewhat, but I think ultimately the judge, trying to tell a judge how he's going to decide what reasonable is, I mean that's an argument one of the litigants is going to make.
I hear what you're saying. We unfortunately deal with these all the time. We deal with public records litigation all the time, and more often than not, the finder of fact, the judge, will look to the statute in which, you know, the standard is articulated in the statute. So, because there is a standard, right? Was this conduct reasonable based on what the statute requires? The statute requires the custodian to determine, did it violate? Not did it potentially violate, did it violate? So again, I would respectfully suggest that I think it accomplishes what the chairman is attempting to do by leaving potentially in there and then leaving the reasonableness determination and changing the may back to shall.
Noted.
Thank you, sir. I'm happy to answer any other questions.
And that's why we
anybody
have smarter attorneys than me.
No, come on
thank
now.
you, Ms. Carey.
Well, and look, and part of my goal is to try to get everybody, you know, the sheriff came up here and said, I don't understand why there would be opposition to this bill. Part of what I'm trying to do is maybe alleviate some of that opposition so that the sheriff could accomplish his original goal.
Also noted, Mr. Chairman.
Yes. Representative Duplessis, do you have a question on the potential amendment on the bill? On what? Amendment? All right, Representative Duplessis. On the bill? Okay, hold on. I'm going to come back to you. I've heard the concerns. I think we're going to continue to work with this on the floor. I'd like to remove the potential right now. If we have that conversation, I'm going to work with the sheriff. If between here and the floor, if this bill gets out, it's the determination's made that that's necessary. I know the sheriff well. And I know you well, Ms. White. I have no doubt that we will be able to work that out. So I want to offer the amendment as I proposed it, removing potentially from those points in concept and also changing the may to the shall. Is there any questions, discussion, or objection to that? Seeing no objection, that amendment is adopted. Back on the bill, Representative Duplessis.
Thank you, Mr. Chairman. Mr. Sheriff, good morning.
Good morning.
This has been an interesting discussion as we try to unpack all the challenges that you have as a sheriff in dealing with requests, public records. I think there's every public institution, whether you're in law enforcement, whether you're in the legislature, whether you're in education, in many cases have to deal with public records requests, probably not to the extent of your agency. And you, I'm sure, rank at the top, as you pointed out, but you're certainly not alone in having to make, and your custodians having to make these judgment calls on what should or shouldn't be released. Chairman Stefanski's amendments sort of address some of my concerns. I still have concerns, but the determination on the potential, what could violate, I saw a lot of issues there. I think by limiting that, that makes it a little better in my opinion, but I'd still have some concerns. What I'd like to get to is to try to better understand, if you don't have body cameras right now, how is this currently impacting your office? And I'm trying to understand. I heard the number 2 million earlier mentioned. I don't know if that's what's currently being spent annually on paying lawyers to fight or deal with these issues in court. I don't know if that encompasses the other lawyers' fees when they win in court.
No,
I'm
this
trying
is
to
just
see
this
how
is
you're
just
being
body
impacted
cameras
right now.
So remember, it's potentially of me being able to spend money to implement body cameras for me in the future.
So that's not even being spent right now.
No. So, right now, I mean, look, I'm going to have public records requests. I'll have lawsuits. I'll have that, and that's going to continue to happen. Having body cameras, just earlier this year, we brought 2 different companies in. We did trial runs with several of my officers to determine, which ones we like, which ones we don't like, what's the good parts about some, what's the bad parts about some, and obviously taking bids from those different types of cameras to make a determination of whether we're going to go to camera cameras or not. I've got to now fit. I know that it's probably going to be, $2 million a year for the sheriff's office and expenses. Let's be honest, y'all. I don't have an extra $2 million in my budget to make that happen. I'm going to try to make adjustments, and that means my, deputies are going to have to do without certain things. I'm going to have to order less cars. I'm going to have to do all the different things and make budget decisions like anything else, right? But if I'm going to implement cameras, I've got to look at what my risk versus reward is. People think that the amount of settlements go down, if you have that. I certainly don't spend $2 million a year on settlements in Jefferson Parish. Having cameras is a community interest, measure, but it's not a cost-saving measure. And so from my perspective, if I'm going to put cameras on my deputies for that community interest, I've got to look at the big picture to see where my cost is. How much am I going to have? How many different people am I going to have looking at body camera footage, not only from my ranking officers before it's submitted, but also my custodians before it's come back on the back end? How much extra is that personnel, those benefit costs going to make? And that sense. So when that came forward, I started looking at all the different states, because I'm not alone. Let's face it, there's agencies larger than me that have cameras. There's agencies smaller than me that have cameras, right?
That's right.
We all have different concerns. It's easier for a city government, a municipality, to put a camera in. Why? Because they don't have the litigation cost that goes with it. A city council can make a budgetary decision and make that happen. As sheriff, I can't. This is what my budget is. This is what I have. So without the ability to lay off 20 different deputies, look, I can have body cameras tomorrow, and I can have a lot less deputies on the street, and my response time can go from 5 minutes to 20 minutes, right? I mean, it's a risk versus reward that I've got to try to make a determination to think. So when I'm looking at body cameras as a whole, does this save me a ton? No. But it puts me in a predicament more and more on a regular basis that I'm going to have to defend. I don't have to defend this at all right now with no cameras. I'm going to have to defend it later on. So before I make the decision to sign on the dotted line on a contract, my conversations with Rodney Lyons was, what can he do to help the sheriff's office get to the point where I can say, yes, we're going to implement cameras. And this is one of the things that I thought legislation was needed to address some of these issues, which is not just going to help Jefferson Parish Sheriff's Office. It's going to help all the other agencies and municipalities that exist. In my case, it's to help me get there. The other one's going to help them maintain it. Mm-hmm. And that's the difference, right?
Thank you for that explanation, and especially pointing out the uniqueness that your parish may have law enforcement versus other municipalities that have councils and have different budgetary type of structures in place. So I realize this is a new area that you are clearly trying to venture toward. I'm hoping that we can get to a place where the community interest that you mention is balanced with whatever fiscal cost there might be. I don't know the data in terms of how having body camera footage will help you in terms of helping your agency hold off on a lot of lawsuits when you can say, here's the footage, here's how the arrest was made. So no, you can't sue me because the video clearly shows that we made a proper arrest. I don't know how that's going to help your budget. I assume it might.
It will, but
Okay.
but the truth of
Right.
it is, when you look at what my costs are today, I'm not spending $2 million on cost.
Okay, but
and that's the
right.
difference. It's so I don't disagree that lawsuits would probably go down, but the issue is my cost is still going up.
Right,
And that's the difference, right?
but again, these are costs that I think are well worth it.
Mm-hmm.
When you talk about community interest, when you talk about public trust, and you talk about overall good policing, that is what we all want. I know that's what you strive for, and that's what I support. So I'm here to state on the record that body cameras are a good thing, and I would like to see it happen, and I want to do all that I can to ensure your office is implementing them to the highest degree. And I don't think we should let the threat of potentially having to spend $2 million stand in the way of that. And when we are talking about how they're implemented and how it's rolled out, Sheriff, that it's done in a way where we can protect people's reasonable expectation of privacy, but we're making reasonable determinations on what is or isn't allowable. And I think that the language that Chairman Stefanski offered up could help there, but I still think it's going to invite a lot of litigation.
And Rep, remember, it's not $2 million. It's $2 million per year. You know, and
Per year.
Right. So
Per year.
if y'all want to send down $2 million in capital outlay for me every year, we can make this happen pretty quickly. But
Thank you for the discussion.
Yeah.
That's the other committee. Representative Horton, you have another question?
I have a question. Thank you, Mr. Chairman. Thank you, Sheriff, for being here, and it is wonderful to see you. And I thank you that this will not only help Jefferson Parish, but it will assist in every department. And I wholeheartedly support what you're doing. I want my privacy and the privacy of our citizens protected. And then we just passed a bill out a few days ago, I believe, to make it where people cannot see the plans of an airport. I believe that something was passed, I don't know if it was last year, where people can't request out the plans of a school. And I mean, you were at an airport investigating, looking under probably every nook and cranny, where hiding place for a bomb. We don't want that out because we want to protect, the integrity of the structure and for the people who would go to that airport. So I thank you for your service, and I wholeheartedly support this bill. And at the appropriate time, I like to move favorably as amended.
Thank you, Representative Horton. For a question, Representative Jenkins.
Thank you, Mr. Chairman. Thank you, Sheriff, for coming down. And I'm just trying to be clear. We've had a lot of talk here this morning, and I'm trying to follow this. But so, does this bill do anything besides address the attorney fee issue? Is that what the whole thing is about?
That's pretty much what this does. The only difference, technically speaking, it changes body worn camera to really any video and audio, because we have so many different cameras now that shoot footage. It really wasn't technically correct to have it as body worn camera video when you have all kind of different other cameras that utilize it. So that would be a technical change from there. The potentially violate. Although that's not dealing specifically with the attorney's fees, it's how to make the address of the attorney's fees on a public records request. But it does not change the law of what is not a public record or what an exception to a public record is.
But I took that out, Sheriff.
What's that?
I took that
I
out.
know, but I'm just, he was asking of whether that was what it was. I'm trying to give you an accurate statement. It does not change the current law of what is an exception or what can be considered an exception to a public records request. This just deals with if an exception is determined by the custodian, that we're going to rely on an exception, and that exception is reasonable, and then I'm not responsible for paying the other side when I am trying, in this case specifically, deal with someone's individual privacy rights. That, in truthfulness, if we went to other states' body cam legislation footage, they're a lot more restrictive. And as I said before, if we had those statutes in place, we wouldn't need this. But I'm not here asking for a stricter standard. I'm not, and I think that would be a totally different conversation if I was coming forward and acting for a stricter standard. This literally gives us a lot of ability to give records that would not be given in other states. But it puts the sheriff's office or the custodian in a position to try to make that determination.
Right. And my question once again, is this bill doing anything other than trying to address the attorney fee? And the reason I'm saying, well, let me rephrase my question, because I'm a proponent for getting the film out. I want the film out. I want the public to see the film. I just want to be sure that what we're dealing with here is not something that's going to prevent that from happening.
No, it doesn't. Well, remember, there are other exceptions in place, Rep, that come place, whether it's an active investigation type of thing, right? Look, there's plenty of times. I've had instances myself that I've had on videotape, where I always bring in, whether it's people in the community that come forward and see certain things. The problem with law enforcement today is nobody wants to wait for the facts, right? And so I can't release a video, even though it may be clear cut and shown, before I get the witnesses to come in and give their statement. I don't want to influence someone's statement by showing them video. I want them to be able to come in and give their statement of what, and then we see what coincides. Any homicide investigation, whether it's a homicide between individuals, whether it's a police officer homicide, whether it's justifiable or whether it's not justifiable, has three different parts to it. You have the coroner's office that will deal with the body, the decedent, who got shot, how they got shot, where they got shot from, what angles they got shot from. You have our crime scene that will be there on the scene to deal with the things of the scene, the evidence, the casings, the angles of where they came from, where a person was standing, the photographs of the scene, all of those type of things, DNA, fingerprints, any of that type of stuff. They deal with the things. Then you have a homicide section that deals with people, deals with statements, and they work independently of each other. Because homicide is supposed to actually take the individual witnesses and bring them in and say, what did you see? What did you see with your eyes? And guess what? There's people that lie to us. I mean, that's just the reality, right? So we're going to bring people in and we're going to let them tell them what they saw. What makes a difference from us is when they say that they saw the person over here shooting, but we know the angle of the bullets came from here. We know they're lying.
Right.
You know,
this is what I'm trying to do, Sheriff. This is what I'm trying to do. I'm just trying to be clear on what this bill is doing because I've read through it a couple of times here, and I'm open to this idea about the attorney fee issue.
Right.
But I don't want any collateral.
This bill, right?
I don't want
just
any
want to be
kind
clear.
of collateral issue. Let me get this out. I don't want any collateral issue coming into play that prevents whatever production that should be made under current law being affected.
No, and I agree. Yeah, I mean, I'm not trying to hide the ball on you by any means, Representative. This bill does nothing to that effect. There are exceptions that law enforcement has in current place that this does not affect at all. But that's what I'm trying to answer you honestly from that standpoint. I don't want you to believe that this bill is going to force a record to be out there or not. It has nothing to do with that.
Okay.
Other exceptions, other parts of the law do, but we're not changing any of that.
All right, thank you.
Yeah.
And now, either you or the attorney can answer this one, and this will be my last question, Mr. Pro Tem. And I was just curious about this. I heard you saying that these cases sometimes end up in court and the judge has to look at it. Does the judge take an in-camera look at this film to determine whether or not it violates somebody's rights, or is this done in open court? How does that work?
So thank you for the question, Representative Jenkins. It is generally an in-camera inspection.
Okay.
Because until the decision is made that it is public record, right, then it should not be subject to public disclosure. And then if that decision is made, of course, then everything's put on the record.
All right. I don't think it's a an easy decision that has to be made. I could certainly understand the concern that's been expressed here. Don't get me wrong. I just want to be certain that we are concentrating on the attorney fee aspect and nothing else. It helps me to be a little bit more supportive of what you're trying to do.
Yep,
Okay?
I agree with
All
you.
right,
Thank you.
Thank you, Mr. Pro Tem.
You're welcome. All right, let me read some cards. We have Ryan Haney. He's present, does not wish to speak. We have Mr. Sheriff Renata, who's present, which does not wish to speak. We have Paulette Bailey Wilson, who's present and does not wish to speak. And we have Brandon Brewer with the LMA, who is present, not wishing to speak.
Mr. Acting Chair, I did have one more thing to say, if you would indulge me, and
Let me finish reading the cards, and then I'll indulge you.
Yes, sir. Thank you.
You're welcome. We have Scott Sternberg, who come up shortly. He wants to speak. We have Morgan Lamondre, who wishes to speak. Then we have Polly Johnson, who's present and will provide information if requested. We have Dana D. Piazza, who does not wish to speak. We have Kevin Hayes, who opposition does not wish to speak. We have, I apologize, I can't read the handwriting, but it's ACLU, present, not wishing to speak. We have Robert Travis Scott, who does not wish to speak in opposition. We have Sean Cassidy, although he's present, does not wish to speak. He's with the Louisiana Foundation Against Sexual Assault. And we have Arwen Baskell with the Association of Broadcasters, who's president, does not wish to speak. Now I'll indulge you before I call up the other speakers. Those are all cards in opposition.
Thank you very much, Mr. Acting Chair. Again, Karen White, Executive Counsel for the Louisiana Municipal Association. The idea here, and I think that some of Representative Jenkins' questions hit the nail on the head there. It's addressing the issue of when these matters go to court. And so here's the idea. You are a custodian. You are bombarded with public records requests. And when you are asked to disclose information about body camera footage or other video or audio footage, you now as a custodian have to make a decision. Is there a constitutional right that is being violated here? And you have to weigh the privacy rights of people who are captured on that footage versus the right of the people to know. The way the law is written, the way Title 44 is written, the way that we train every one of our members is you always err on the side of disclosure. The people have a sacred right to know. And so if there's ever a question, you always err on the right of making that record public and disclosing that record. So in situations where custodians feel like they must withhold that because there is a compelling constitutionally protected privacy right, if they get it wrong, the stakes under current law are very high. You're going to get popped with sanctions and penalties if you are trying to protect the constitutional privacy rights of someone featured in footage. So the whole idea behind this bill is to simply say, if you make that very difficult determination after weighing out all the evidence to withhold that, you are brought to court and you lose, that sanctions are not necessary, meaning the judge is not compelled to grant them. The judge may grant them. So I appreciate what Sheriff Lopinto has brought. Happy to answer any questions.
Thank you. There are no questions. We're going to move to the opposition now. Mr. Sternberg.
Good morning, Mr. Acting Chair. If I may go first.
Sure, that's no problem. Please just identify yourself for the record.
Morgan Lamondre. I work for STAR, stands for, our acronym is Sexual Trauma Awareness and Response. And I've actually never been before this committee before because the issues that we deal with, which is dealing with sexual assault, do not typically come before your committee. But this particular bill does cause us some concerns because of sort of an access to the court situation that we're seeing. If all of you are familiar with what has been happening at LSU, the AG's office, and being able to access documents to uncover systemic abuses, as well as for survivors to access their reports from law enforcement. I know we're talking about body camera footage right now, but this bill amends Section 35 of Title 44, which is dealing with all public records. So it doesn't matter if it's, trying to request records from LSU, from the AG's office. This means that there would be no mandatory, which I think there may have been an amendment, but even with the amendment, if it still has that language about if the judge determines there was no reasonable basis for the denial by the custodian, that still, makes the bar pretty hard for somebody to have attorney's fees. So Representative Jenkins, you asked, is this going to affect the ability to get the film? I believe it affects the ability to get any of these documents because right now we are able to have access to attorneys for people who are trying to obtain these documents because of the attorney's fees provision. So if you have a good case, you know that there's that potential to not have to come up with the money up front. So this is going to affect people who can't afford an attorney to go to court to obtain these documents and these records. And like I said, we're dealing with every single type of public record. We're not just dealing with body camera footage here. So I'm concerned about that because we're amending the enforcement section, not just the body camera footage issue. So I'm happy to entertain any questions, but we have concerns. This is an access issue for us. This is uncovering, systemic abuse that you've seen sort of happening in our state. And we believe that survivors have a right to obtain those documents. And when they get pushback, this allows them to obtain representation without having to come up with thousands of dollars for a retainer agreement to seek private counsel.
Thank you. Mr. Sternberg, there's no questions. Mr. Sternberg?
Thank you, Mr. Acting Chairman. Scott Sternberg, Louisiana Press Association. I'm disappointed to have to be here this morning. I've tried to work on this bill from the very beginning and have been stifled at every turn. the representations that you have heard from my sheriff, Mr. Lopinto, and my friend Karen White can be generously described as inadequate. I'm not going to say that they're lying, because they're not. They're just not giving you the whole picture. This bill rewrites the Louisiana Public Records Law that we wrote in 1978. And when Mr. Lopinto makes a decision whether or not to turn over a record, he makes that decision with the knowledge that if I look at this video and I err on the side of privacy, then I might get popped for $500 of attorney's fees. That's what we're talking about here. We're not talking about $30,000 of attorney's fees. I litigate public records cases all over the state of Louisiana, and most of the time we don't even get them. Even though they're required under the statute, we get $500. It doesn't cost $500 to litigate a public records case, right? I mean, in the Samantha Brennan case, which we just won, that case costs way more than the $10,000 that we were awarded in that matter. And in that matter was some pretty egregious stuff. Now, 4 years ago, we put together a body camera commission. And that body camera commission met, and they came up with these guidelines. And I wish that Representative Horton was here, because I agree with her. I am one of the people that helped, with Karen White, write this provision that says that video that violates an individual's right to privacy shouldn't be produced. That's language that I worked on, because I believe that that's the case. I think that when you go into a home for a domestic violence issue, when you are dealing with, domestic violence is unfortunately the best example, a sexual assault issue, when you're dealing with something that would violate someone's privacy, then yes, that information, that body camera footage is exempt. And that's why we put in the statute the ability of the sheriff to withhold that information, or the Louisiana State Police to withhold that information. But changing the body camera law without reconvening that commission that spent a ton of time coming up with this law, or talking to the experts, or even talking to the people who are interested in the body camera footage, like, for example, the criminal defense lawyers aren't even here because this bill was scheduled last night. And I don't know what else to say other than rewriting 4435 will absolutely destroy public records litigations in this state. People will not file public records lawsuits if they don't have some guarantee of getting their court costs back. It costs $1,300 to file a public records lawsuit against the state of Louisiana in Baton Rouge, and that's just the filing fees. That's a lot of money. And then you're talking about attorney's fees on top of that, and it's not like we're getting $100,000, $200,000 awards here. We're talking about reasonable attorney's fees and costs. And those judges, who are wonderful judges and are elected, and they're dealing with their elected officials as well, sometimes have to cut a balance. And they say, well, look, the statute says I have to award you attorney's fees, but I feel bad for custodians. So Mr. Sternberg or your client will be awarded $500 of fees. That's just the example of how the mustard gets cut right now. I don't know where this is coming from. We don't even have body cameras in Jefferson Parish, but there's a better way to do this. This bill should not pass this committee, and the way it has come forward this morning is just extremely unfortunate. Extremely unfortunate.
All right, we have a question from Representative Ivey.
Thank you, Mr. Acting Chair Pro Tem. I appreciate the perspective that you bring on what is, for me, is about as serious of an issue as we can have as a legislator with regard to public access to public records. So I appreciate your hyper focus on this issue. It really is intended to protect the public's interest on every subject. And as was stated before, I understand the deference for, agencies and custodians of records to, err on the side of caution in some cases. And I believe in this subject matter, we should err on the side of caution before we proceed with some of these substantive changes to the records law. I believe there is a better way to address this. I can't say that it exists in the bill in its amended posture, and that we'll be able to really confect something in a comprehensive, responsible manner, right now. And so, Mr. Chair, at the appropriate time, I'd like to, or Acting Chair, I'd like to make a motion to voluntarily defer the bill at the appropriate time if no one's made another motion. We've already got Dennis to what?
We already have a motion, so
It'd be a substitute motion. Yes. Well, he just stepped out. He was right here. At the appropriate time. So again,
it might be the appropriate time. There's no questions right now.
I believe it deserves more thorough vetting, more conversation with the groups of stakeholders who've been participatory in this process. And again, haven't had the time to personally go as deep as I prefer to on the subject myself.
Thank you, Representative.
All right, we have a substitute motion by Representative Ivy. What's that? We have a substitute motion. Let's do a quorum call. We have a question on quorum. Sure. Representative Gadberry is going to ask a brief question while we twiddle our thumbs.
I just got a curious question.
Sure.
Is it not, at what point do you release footage? Is it prior to court? Because if you release it too soon, I would think you would bias a potential jury.
Are you talking about?
Yeah, we're not talking about, and I don't think this bill in particular, and I believe Sheriff Lopinto said earlier, we're not talking about like criminal activity or anything like that. If it's associated with a crime, it's a part of that investigation and it's already exempt. This
civil cases, not criminal cases?
It's like car accidents or somebody goes into somebody's house because there's a civil disturbance type thing, and the custodian looks at it, decides whether it would violate, and if it does, then he doesn't give it over. If he decides that it wouldn't violate, then he gives it over. And the attorney's fees is kind of the penal portion. Like, that's what he has to weigh against. Otherwise, without that penal portion, every time they're going to err on the side of, maybe not Sheriff Lopinto because he's one of the good ones, but there's certainly some of them out there that are just going to say, you're not getting anything, sue me.
But eventually you can give it up.
Yeah.
After the case is over, or...
Yeah, if you have the money.
The discovery from an attorney, you give it up at some point.
Theoretically, yes. Theoretically.
Thank you.
All right. So we have make it brief.
It'll be brief. Just a point of clarification. Your primary concern is that if we make it permissive for the attorney's fees, that it will have a cooling effect on anyone who intends to go get a public record of this variety, because all of a sudden everything will have to go, more things will go to court, and the fact that you're at risk of getting your attorney's fees, it just makes it more difficult for people to file those requests.
Well, it makes more people I'm sorry, Morgan, they don't have the big stick, which is, I'm going to sue you, and then when I win, you're going to have to pay my attorney's fees.
So now they go through the effort to sue for something that they were correct in receiving, and then the judge says,
exactly,
right.
Which happens a lot.
Even though I think the amendment changed it back to a shall, that provision at the end, if there's a reasonable basis, that still sort of.
And I'm gonna guess that the majority of the things that have to go to court are not over trivial nonsense type privacy related issues. These are substantive issues where it requires a lot of effort, a lot of time and effort on legal expenses.
And I have a great example, Representative Ivy, if you want me to give you one about body cameras.
I asked for brief on purpose. I don't want to rehash.
I do appreciate it, but I want to make clear to everyone that this is the real issue, that we don't want the public to no longer effectively make these requests because they're going to have to go to litigation and then maybe not get their recovery costs.
And I'll give I'll give Mr. Sternberg an opportunity to briefly respond to the statements made by her.
I had a case for the advocate against the state police about body cam footage that had nothing to do with criminal litigation. It was somebody who got pulled over on the side of the road. That person was a state police officer, and we had to sue the state police. The judge reviewed the video, and the judge said, I have to give you attorney's fees, but I feel like the custodian was, doing right, so I'm just going to give you $500. And it costs way more than $500 to do that. So that's my point.
Thank you. All right, this is where we are. We currently have a substitute motion by Representative Ivy to voluntarily defer Representative Lyons' bill. We're going to give Sheriff Lopinto a brief opportunity to close on this bill since he was the presenter. Sheriff, I'm sorry. Go ahead.
Thank you very much, Rep. Cadbury. I figured I'd just address it. This is really nothing to do with criminal actions. Criminal actions, those are going to be handled the same way they normally have. It's the 300,000 calls for service that I have that are in criminal actions, right? And those are the issues that, I have in place where a person has an interaction with a law enforcement officer. Me and you have an interaction. If you come in and make that request for the video footage, the truth of it is, at that point in time, if I refuse it to you, you're right, I should pay. Because what privacy if I'm protecting if you're the one that's making the request, right? Now, it's when a third party is coming in and make a request on something, on an interaction that happened in your home that's not a criminal act or whatever the case may be, whether or not you want it released or not. Truthfully, if you sign a waiver off of it and I'm out of it, I don't care who gets a copy of it, right? But am I trying to protect your privacy right for an interaction because I happen to be videotaping, at that point, am I involved in that fight or not involved with that fight? That's what these issues come in place. Most of the criminal actions or sexual assaults, those are applied by all kind of other different laws, and that I'm still going to have to deal with, right? But that's part of the normal. It's the only difference in this is when body camera footage is taken, most of these cases don't have a report. They don't have anything written with them. They were marked up N18, necessary action taken, but we still have body camera footage that exists. Now, what is reasonable, and that's the definition of what is reasonable of whether I'm protecting or not protecting somebody's privacy right. And that's what I tried to address here, and I tried to address it narrowly. Obviously, there'll be people that will be against it, but I tried to do my best to address it as narrowly as possible to deal with those type of issues so the custodian is not being put in the middle of things that we don't necessarily have fights over. So I hope that answers the question from the opposite side. And
thank you,
start, close.
Representative.
Okay.
Okay, members, I think we had a substitute motion for voluntary deferral, and I'm going to object to that. And we just want to, I think this has been debated all the way through. I came in and heard a lot of different arguments with here, and what the sheriff presented and the sides there. So I'm going to ask for your favorable passage of it.
Thank you. All right. So just to be clear, I'm going to say for the third time, we have a substitute motion to voluntarily defer Representative Lyons' House Bill. What number are we on? 470. And members, please bear with me. I'm also making the quorum in education right now, so I'm back and forth doing two jobs at the same time. Madam Secretary, you please call the roll. If you vote for the bill, a yes means you're voluntarily deferring Representative Lyons' bill. If you vote no, you're voting against voluntarily deferring Representative Lyons' bill. My apologies. Now can you please call the roll? As soon as I give you.
Chairman Stefanski? No. Vice Chairman Duplessis?
Yes.
Yes. Representative Boyer? Representative Carter? Representative Desitel? No. Representative Farnham? No. Representative Gadberry? Yes. Representative Hodges? No. Representative Horton? No. Representative Ivy? Yes. Representative Jenkins? Yes. Representative Johnson? Representative Lacombe? Yes. Representative Lyons?
No.
No. Representative McGee?
Yes.
Yes. Representative Newell? No. Representative Thomas? No. Representative White? 6 yeas, 8 nays.
The bill is not voluntarily deferred. Back on the original motion to report the bill as amended. Is there any objection to reporting it as amended? Seeing none, it is reported as amended.
Thank you, members. Y'all have a great day.